Okay, so now today we start with chapter 6 under module 3 of the new syllabus, and we'll talk about the rights of the arrested person and a reference of the Constitution of India, Article 22, in the context of the rights of the arrested person. So, there are a set of sections which we have to study under this chapter, which is first one is section 47 to 58, which is coming from chapter 5 of the Sanghita, which is arrest of persons. While section 77 to 78 is something which is coming from chapter 6, which is process to compel appearance. And section 340 to 341, which is mentioned, is the general provision as to inquiries and trials under chapter 26. That's we will study. So we'll be moving between chapter 5, 6, and 26. So the very first section we study in this chapter is under this rights of arrested person is section 47 to 58 from arrest of person, chapter 5. The first section is section 47. 47 says, the title says, the person arrested to be informed of grounds of arrest and of right to bail. So all these sections what we are reading under this right of arrested person, the moment we'll go back at the end of this chapter and we'll talk about the Constitution of India's role through Article 22, you will see whatever we have discussed here is somewhere reflecting there in Article 22, and that is from where it is coming. So any person who is arrested has to be informed of the grounds of arrest and of right to bail. So the person, as we have discussed earlier also, the people who are arrested are considered to be accused until and unless they are not, it is not proved, they're not proved guilty, they are considered accused. So they are accused of certain crimes, but still there is a possibility, a finest of, smallest of possibility where it is quite possible that person might not end up being proved guilty for whatever reason. So in that case, the Constitution, the provision allows us that every person who is arrested to know exactly why the person is arrested. That is his right to know. And the right of bail, the person knows that if what kind of bail and how the bail the person can get. So section 47 wording, subsection 1 says, every police officer or other person, we know that the person who is arresting could be a private person also, apart from a police officer. Anybody else could be there. So every police officer or other person arresting any person without warrant. Why without warrant? Because in case of the warrant is there, it is already written on the warrant. We know that when the warrant is issued, all the reasons has to be captured on the warrant, why the warrant is issued. So that is why, so every police officer, other person arresting any person without warrant shall forthwith communicate to him, tell him that full particulars of the offense for which he is arrested or other grounds for such arrest. So whatever is the person, what for what offense is it, under what all grounds the person is being arrested. Subsection 2 says, where a police officer arrests without warrant any person other than a person who is accused of a non-bailable offense. So other than a person who is accused of a non-bailable offense, because it's a non-bailable offense, so he should inform the person that he is entitled to be released on bail and that he may arrange for sureties on his behalf. So whenever the person, police officer, who is arresting somebody without a warrant, that person who is accused of a non-bailable offense, who is accused of something which is bailable offense. So anything which is not a non-bailable offense, a bailable offense, in that case, he shall inform the person that you are entitled to a bail because it's a bailable offense. You can secure a bail for yourself and for your freedom, and you have to arrange so and so security on his behalf. And why subsection 2 says only for the police officer, while the subsection talks about the police officer and anybody else arresting? Because when we have read until now, we understand that the police officer can only ask the surety. The private person who is not a police officer cannot ask for any surety bail bond. It can only happen even if the private person under subsection 1 has arrested, told all the reasons. then he has to hand over him to the police station or a police officer, and then subsection 2 will apply, and the police officer will tell that person, okay, you have been arrested for a non-bailable offense, and you are you can secure a bail for yourself, and this is what the section talks about. And that is why subsection 2 has only police officer, not the common person or a non-police officer. So what is this section talking all about? This section is talking about the obligation of a police officer. It's a police officer's obligation to ensure that the person who is arrested is informed correctly when he's been arrested without a warrant, to for the reason of his arrest and his right to secure a bail for himself or herself. So communication on the grounds of arrest has to be given to that person, and it has to happen immediately. So because shall forthwith is the wording given there. So it has to be told immediately to the person that this is what has happened, and providing full particulars of the offense or grounds of arrest, why he has been arrested, and a right to bail, what the person has, he could secure. The provision emphasizes also that the arrested person's right to seek bail is not he is made aware of that, and he is not losing that opportunity also, so that the person what sureties and what bail is required is aware, and he can make that arrangement for himself. Because as we have been talking already in multiple chapters, law looks into the minimal punishment as much as possible. The purpose of the law, as far as possible, until there is a heinous crime, is in any court, the way it is handled is to ensure that a fair trial happens, both the parties are heard, and the person is brought back as much to the mainstream society, rather than punishing him and locking him behind a bar. So protection of the individual right is something which is taken care in this particular section, and the individuals are informed both of the ground and the bails, etc. So he is not in a complete uh, loss of the situation where he is not aware where I am or why I've been arrested, and do I have an option to go out on a bail. So this is something which is a protecting an individual right, and treatment is fair. So it is an accountability on the law enforcement, that they have to ensure that the person is immediately aware of that, and it empowers the detainee also with whatever rights they have. So this is a legal protection given to the person who is considered an accused. Now, section 48, then we move to the next section. Section 48 says obligation of person making arrest to inform about arrest, etc., to relative or friend. Now, what has happened is the section is around where the person is arrested. Now, if the person is arrested, he himself would know what grounds, on what reasons he is arrested. He himself would know what bail options he has. But then, end of the day, he is in custody. So then there is somebody there for his freedom, or for his execution of his rights, who can support him from outside the custody. And that is why this is an obligation again on top of that obligation, where he has to inform the person being arrested. The police officers or the person who is making arrest is to inform the friend or any kind of relative which the person indicates, the accused. So it has to be, if not a relative who is staying there, it's a friend indicated by the accused who could be helping him. Otherwise, the purpose is lost. So every police officer, the wording says, or other person making any arrest under this Sanghita shall forthwith give the information regarding such arrest, and place where the arrested person is being held. So which police station, which place the person is being taken care, being arrested and kept there, detained there, that information to any of his relative, friend, or such other person as the disclosed by or nominated by the person who is arrested. And for the purpose of giving such information is to designated police officer in the district has to be given. So in case it's a non-police officer, then the police officer will also has to be brought in loop immediately. So wherever the police is taking that person, that police station or that particular station where the person would be kept, and what are the charges, on what grounds he is being arrested, and what are the bail options, etc., etc. The information has to be given to the person detained and a relative, friend, or somebody who is nominated by that person. The nomination is very, very important here because it has to, the person is to be guided and supported in a way that he or she is getting maximum support for his liberty, the rights what he can claim rightfully. And if the person is not nominated correctly or not the right person is being informed, the purpose is lost. Subsection 2 says the police officer shall inform the arrested person of his rights under subsection 1 as soon as he brought to the police station. And subsection 3 says an entry of the fact as to who has been informed of the arrest of such person shall be made in a book to be kept in the police station in such form as the state government may rule provide. Now, this is a control set because there is quite a possibility in heat of moment, in being busy, or probably in a situation where the person might uh, just one minute, huh? Be illegally detained by the police officer. So, in all such scenarios, or the police officer is not following properly the rules given in the previous section and this section where he has to inform somebody. So, to ensure that is done, that has to be written on a book which is kept in the police station, which is a confirmation. So, which is securing again the rights of the person who is being detained. Section Subsection 4 says, the subsection part says, it shall be the duty of the magistrate before whom such arrested person is produced to satisfy himself that the announcements of the requirements of subsection 2 and subsection 3 has been complied by with the respect of such arrested persons. Now then a judicial oversight is brought into. So there is a rule which is given, has to be followed. Then there is a control set in the police station. Now you enter also in the book that you have mentioned so and so persons. It's a definite record which you are giving. It cannot be a vague record that I have reported to his relative. It cannot be written. I've related exactly so and so person who stays in so and so place and who has got so and so mobile number or phone number. So this is a definite account the police has to give. And then after that, everything what happens once the magistrate sees that person and he is brought to the magistrate will come back and check, was he given that particular information? Was his relative informed? And that he will check also into the book which the police has made an entry. So subsection 2 and 3, requirements of the arrested person was informed about his right and informed about the grounds, and his relatives were informed. So that is something which is very, very important aspect and which is overseen by the magistrate, which is a judicial oversight which is done. And the very key components of this section, if we come back reading the section again, is a immediate notification. In the previous section also and this section also, it is immediate because until and unless you don't do, through the other sections also, the person during the interrogation has a right to avail services of an advocate, and that is what maybe in not all the stages of the interrogation, but then that person has a right to take an assistance. And for that reason, the person should know what grounds he's being arrested on, and his relatives should also know where he's being taken to so that he can take the right remedy for his securing his freedom, or at least, securing his rights. So it mandates then that it has to be immediate. That is why it has to be immediate. The right awareness is also to be given. So police officer's role or anybody who's arresting's role is not only to arrest that person, detain that person, it is also to fairly educate that person also on the kinds of crime he has done, which is considered, kinds of actions he has done, which is considered crime, and so crime and so sections, and then the person what are the kind of crime he has done, bailable, non-bailable, and if bailable, what are the rights, non-bailable, what are the rights. So all those things has to be notified to the person and their relative also, and a proper entry in the police station book also has to be made, which has to be verified by the magistrate on the first occurrence when the person is presented in front of the magistrate. So documentation of the notification is done here. That is something very, very important. And then that documentation is also validated, and verbal confirmation also from the accused is taken by the magistrate, which is a strict judicial oversight which is sent over. So if you see a lot of sections, we are seeing that there are rules which are made, which are laws which are made. The process is established, the procedure is established, but on top of that, a documentation is also established so that that is definitely somewhere a record is made. But on top of that, in most of the places, wherever an execution is happening through some kind of law enforcement agencies or some other agencies, there is always a judicial oversight attached on that. In fact, even on the lower level of judgment, lower courts, when the judgment is coming, there is also a judicial oversight attached always through the appeals, etc. So in that case, always a judicial oversight is required when a law enforcement agency is in action. It's by default, that's a logic, that's the principle which is for it. So this brings a transparency in the arrest. It gives us support for the detainee and it enhances the legal process, because this is not the British time when somebody has to be detained and has to be vanishing without any law to be kept in mind, and somebody has to be bashed, thrashed, and maybe killed also under custody, and nobody knows about that. This is a democratic country where we have people availing the services of the legal services, availing the services of the various law enforcement agencies where they are by default serving them. And it is very, very important for those agencies to act like, unbiased by book. So that in that case where there is a right of a person, in spite of being marked or tagged as a accused. Being accused is what? Being accused is a tag which is added to the person that he might be a person who is guilty or might be convicted. So there is, in the criminal laws, it is a very strict principle. Until and unless there is even an iota of a small doubt where the person might not be guilty, the person is not considered guilty and acquitted. That is why the rights has to be protected from day one, considering the worst case scenario, which is the best case scenario for that accused. Coming to section 49, which is search of arrested person. So subsection 1 says, whenever, number 1, a person is arrested by a police officer is under a warrant which does not provide for taking of bail, or under a warrant which provides for the taking of bail, but the person arrested cannot furnish bail. So what is the key ingredient we see in the subsection 1 is, this is a person arrested by a police officer. Why? Because the subject of taking bail, possibility of bail or possibility of bail not being fulfilled by the person being arrested is in question. It cannot be done by a common person who is not a police officer. This has to be, procedure is only attached with a police officer. So a person is arrested by a police officer under a warrant which does not provide for taking a bail. So he has to be arrested. Or a warrant which provides for a bail, so that could be endorsed on the warrant and returned back to the magistrate with the bail documentation, etc. back. The person itself is not able to provide the bail, which means he still has to be arrested in both the cases. So it's a compulsory arrest situation, what we are talking about under subsection 1. Subsection 1 part 2 says, a person is arrested. So whenever a person is arrested without warrant, the previous all sections what we are studying right now, or by a private person under a warrant. So the courts might have given a warrant to another person when there is no police officer and cannot legally be admitted to bail. So in case of this situation, and the person cannot be legally admitted to a bail or is unable to furnish a bail, the officer making the arrest, or when the arrest is made by the private person, the police officer to whom he makes over the person, because private persons cannot take bail, make over the person arrested, may search such person and place in safe custody all articles other than necessary wearing apparel found upon him, and where any article is seized from arrested person, a receipt showing the article taken in possession by the police officer shall be given to such person, which means the person who is arrested without a warrant, or a private person arrest and pass him on to a police officer, there is a no bail possibility, or he is not able to furnish the bail as in part 1. The officer making the arrest, uh, the police officer to whom he is sent by a private person, in that case also may search that person. it might be required to search that person and place in safe custody all articles. So it has to be placed in a safe custody, all the articles on him. So what are the articles on him? Everything and anything apart from the necessarily apparel. So necessary apparel is the basic clothing, the basic uh, things what is considered to be a basic covering his body, which is necessary, and that those basic things has to be left on him, and everything else has to be the articles whatever found on him has to be taken out, put in a safe place, and it has to be listed in a list showing what articles has been found on his possession. But this can only be done uh, at that point of time to ensure that recording is properly done to secure whatever thing is found on him safely, to return him at right time. So subsection 2 says whenever it is necessary to cause a female to be searched. I mean, when you talk about a female, automatically these considerations would come that the search shall be made by another female with strict regard to decency. So it has to be done very decently. It cannot happen that a female checking a female could cross the limits of decency and unnecessary trouble or make her feel ashamed of that particular situation. So this is a circumstances of searching the person, whatever things on his person to be uh, taken out, listed out, and preserved safely at some place. That is what the section is about. And in case a person who is arrested under a warrant without an option for bail, or under a warrant that allows for bail, but he is not able to furnish the bill, which is a definite arrest condition. And a person who is arrested without a warrant or by a private person a warrant, and then the individual cannot legally be admitted to a bail or cannot furnish the bill. So in either of the way, the situation, the officer carrying out the arrest or the police officer to whom the arrested individual handed over is authorized to perform a search. So the private person is not able to do the search. He has to hand over him to the police officer because it is not allowed to the private person. It is also very important aspect which is ingredient for many of the matters in the court where the private persons wherever involved they have a limited right. They cannot have a right where they can go ahead and make such kind of search on the person, because touching a person for the sake of taking a custody of the person is also very well defined under BNSS, and it is also given if the person submits himself to the arrest, the touching is also not required, manhandling is not required, unnecessary restraint is not required. Very same way, when a private person does it, he has to use only necessary restraint, and if whatever up to the level to ensure the person is delivered to the police officer or a police station. Nothing beyond that is his right. So that is why the private person cannot go ahead and make a search and seizure. And in that case, if a search is made and a list is made and signed by a private person, that list is not even valid. It's an against the law. If by chance if it is done also, it has to be revalidated by the police officer. Now, what is the purpose of seizing these things? There are two things. One is to see if some incriminating materials are on the person. So some kind of a bullet, some kind of weapon, some kind of substance, narcotic substance, or something, some kind of note, some kind of cheats in case of the financial crime, etc., etc. If anything is found on him, might be incriminating. Second thing is to definitely going ahead and safekeeping of the seized item, because the person will then has to move to various levels in the interrogation, etc., etc. All those things need to be preserved safely separately so that he can receive it later. So it is the thumb rule that except for the necessary clothing the apparel the person is wearing, this person has to ensure this person has to be devoid of anything, everything, whatever he or she is carrying. So it is a mandatory for the police officer to provide a receipt when they take all those things and maintain a transparency. Normally, this is packed in a bag and marked with the fire number, etc., and kept in a safe place. Then this section talks about the female arrest, and very interestingly, it talks about two things. One, it talks about female has to be searched by female, which is a common sense based, which is no everybody would understand. But what is very interesting, and on top of that, which has to be understood by an advocate or a lawyer is even a female cannot go beyond the decency. So there are live cases we know personally in many of the cases, and in the various police stations, there had been actions against such lady constables also, where they have used filthy languages. They have made the person undress in front of two more constables, which is not necessary, or the person has been manhandled and forcibly devoid of the clothing to check. So all those things are happening in the police stations. To control that, there has to be some rule which is calling it invalid, and that is why this section talks about it. In spite of a female searching a female, it has to be in all limits of the decency. So it brings an ethical standard in terms of searching a person, ensuring the accountability of whatever is there, bringing an extra safety layer to ensure any incriminating material is not left from the investigation, and in case of females, a very strict environment has been instructed where it has to be by a female, but female also, it has to be under all levels of decency. So what it is doing in nutshell is it's saving the basic protection of the right. It brings the integrity of the evidence, and it also is a very gender sensitive law. That is what it is. Let's move to section 50. So it says power to seize offensive weapons. So whatever the offensive weapons, what is the power to seize? So the police officer or other persons making an arrest under his Sangita may immediately after the arrest is made take from the person arrested any offensive weapons which he has about his person, and shall deliver all weapons to so taken to the court or officer before which to whom the officer or person making the arrest is required by Sanghita to produce the person arrested. Now you will say, if section 49 is talking about already the search of the person, why there is a need of the separate section now? The reason is the previous section is talking about preserving the articles and looking into the incriminating things. So now when you have found an incriminating thing, which is a weapon, what would you do? So it needs a separate guidelines to handle those situations when you have a weapon. So this section is specifically talking about on person, if you find something which was hidden or quite visibly, that kind of weapon you have to bring in and seize and produce to the court or the magistrate where the person is to be produced, because that becomes again a clear evidence against the person to the magistrate to note that what exactly could be the proximity of the crime, because of the person is actually holding some kind of weapon. Of course, that is not a conclusive proof, but yes, that is again something which is a very solid indication. So this section basically granting the law enforcement officer authority to seize any offensive weapon found on the person who has been arrested. So this is a special section on top of 49 about if you find a weapon, then what do you do? So this is an authority to seize a weapon, because weapon is not something a simple object, a pen or a pencil. Weapon has to be in hands of people who have authority to check to keep it in their hands or in their person, or they are licensed to do it as a private person. So in case if that is found, that has to be uh, kept aside. And the section explicitly permits the police officer to make an take the possession of such weapons, and it has to be immediately done, and the delivery of the seized weapon has to be to the respective court. So this is multiple aspect of it. It is again something which is a very strong incriminatory indication about the person. I'll not call it an evidence. And then it is also a safety perspective. Also, it is very, very important, because with a weapon, if a person is left, it's quite dangerous. And if it is not put in the right places, it is again something very dangerous. And it is brings a standardized procedure. So that is the reason on top of section 49, 50 is written to special case when you are searching the person, you find a weapon. And again, this is a deterrent effect of non-compliance. So basically, if any person who has got a arm which is on their body and it is found, it becomes a deterrent effect on the criminals also, that yes, if I am found with a weapon, I have to part with my weapon. So they would try to uh, not do it going further. Anyways, coming to section 51. So we are still in the sections series 47 to 58. Now we reach section 51. 51 is examination of accused by medical practitioner at request of the police officer. Now, I spoke about it earlier also. I'll again speak about it. It will freshen your memory. Is Section 1 talks about when a person is arrested on charge of committing an offense. Of course, the person is always arrested on a charge of committing an offense of such a nature and alleged to have been committed under such circumstances that there are reasons ground for believing that an examination of this person will afford evidence as to commission of an offense. It shall be lawful for the registered medical practitioner acting at the request of any police officer and for any person acting in good faith in his aid and under his direction to make such an examination of the person arrested as is reasonably necessary in order to ascertain the fact this may afford such evidence and to use such force as is reasonably necessary for that purpose. So this is has to be read very carefully because it has a lot deeper meaning. So when a person is arrested on charge of committing an offense and it is of such a nature and it is alleged to have committed under such circumstances where there are reasonable ground for believing that it can be connected through the examination of the person, some evidences which will come out, which will be indicative of that offense. For example, what could be such crimes if I say it's a rape where the person if committed is somebody who is has committed such an offense, a quick medical test with his body test, etc., will bring in such biological samples, etc., which would be indicator of that particular or his body organs, current position, etc., would be an indicator. Then a murder case also. If a person who is, of arson also. So all those cases, if the person, if he's has got some burn injuries while trying to burn something, or he has got blood stains, or he has some struggle marks on his body during a scuffle. So in all those cases and many other cases, although now it is the other sections also govern. Apart from that, that any person who is arrested has to be actually brought to the medical officer to ensure that his health is also monitored while he is under custody. So that is another thing. But in this particular section, we only talk about the such circumstances in part 1, subsection 1. So it has to be lawful for the registered medical practitioner. So we'll have the meaning of the registered medical practitioner here at the last part of the section, which is clearly given there what exactly it means. And acting at the request of any police officer. So any police officer's request, the registered medical practitioner can comply, or any person acting in good faith in his aid. So there are possibilities where there is only one police officer, he's injured, etc., and he wants an help from somebody. So that aid of that person or some other government official or a private person. So in his direction to make an examination of the person arrested as is reasonably necessary in order to ascertain the facts. So some facts has to be determined using his arrest and which may afford such evidences. Some evidences might be brought forward. And say, for example, in case of rape, the persons on that person's body, definitely some or other places, biological traces of the victim will also be found. And that is very, very necessary. Or maybe some biological evidences, samples has to be taken from that person, which would be matched with the biological stains and the samples found on the person of the victim. So these facts may afford such evidence, or in murder cases, or some kind of scuffle has happened. So on the body of the person, if some scuffle has happened, some kind of nail injuries, etc., where a biological stain is found of the other person and the blood stain of the other person is found on the cloth. So all those things may bring in evidence and to use such force as is necessary. So the concluding statement is also very, very important, that the reasonable force has to be used. Now, this is a very, very interesting thing. Whenever we talk about reasonable thing, discretion thing, it has to be reasonable, means it has to be definitely that firm and that solid that the person is brought there and is medically examined. But it cannot be beyond that particular level that it again causes some kind of harm or injury to the person, or a death of that person happens, or anything, some serious thing happens to that person. So it cannot be the level. What is a test condition is the force has to be such that the purpose is solved in spite of whatever force the other person is trying to put to get away from that situation, but it cannot be something which is aggravating the current medical state, mental state, or health of that person. So that has to be taken care. Mental state, anyways, could be waived off, but physical state of that person cannot be tampered with. Subsection 2 says, wherever the person of a whenever the person of a female is to be examined under this section, the examination shall be made only by or under the supervision of a female registered medical practitioner. So it has to be done by or under supervision of a female registered medical practitioner. Subsection 3 says, the registered medical practitioner shall, without any delay, forward the examination report to the investigating officer. Otherwise, there is no point in doing it quickly. So examination in this section, and as per for the section 52 to 53, further also, the examination shall include the examination of what examinations are included? Blood stain, semen, swabs in the case of sexual offenses, sputum, which is the saliva, sweat, hair samples, fingernail clippings by the use of modern and scientific techniques using the DNA analysis, profiling, sampling, and such other tests which is registered medical practitioner thinks necessary in a particular case. So whatever they feel necessary, all those things has to be brought in. And the registered medical practitioner, which has been called out again and again here, means a medical practitioner who possesses any medical qualification recognized under the National Medical Commission Act 30 of 2019 and whose name has been entered in the National Medical Register or a state medical register under that act. So that person could be called as a registered medical practitioner here. So it is something which is an authority of a medical examination given to the police officer or to somebody who is in his aid, who is supporting him. So this is an authority of medical examination. When the word authority comes, authority makes thing do. It doesn't wait for things to happen. So authority is something which will give this police officer and the person in his aid to ensure that, number one, for the sake of this section, it is ensured that the relevant evidences which could be obtained on person of the body with the thorough examination, medical checkup of medical examination of that person as prescribed by the registered medical practitioner is collected and those evidences are not lost. It also brings a special consideration as necessary for the female arrestee, where it has to be definitely by a female who has to examine or under the supervision of a female registered medical practitioner. Either of them is possible. Why under supervision of female registered medical practitioner is also sufficient, because the sole purpose is to ensure that the right extent of examination is done, not beyond that, and to ensure that the dignity is saved. So as much as possible, a female only has to do it. And because there are a lot of invasive techniques which are used on the body of a female, where she has to expose a lot of body part which could be examined. And that is why it is very much necessary to be very sensitive around that. Then it talks about a timely reporting. You do all these things, but you have to turn around fast and you have to give the investigating officer quickly a report back. Normally, it has to become given within the 7 days of time. And the examination scope is all biological samples, including the hereditary material also, so DNA. And definition of the registered medical practitioner is also given. So it gives the particular section brings a enhanced evidence collection guidelines and protections of individual's dignity, especially in case of a female, and integration with a scientific practice is also, which is part of section 51. Now we move to section 52, which is examination of person accused of rape by a medical practitioner. So it doesn't mean the person is accused by a medical practitioner. It means an examination of a person who is accused of a rape, and that examination is happening by a medical practitioner. So the title sometimes lack the commas and the full stops. It sometimes makes a different meaning. So coming to subsection 1 of section 52, when a person is arrested on a charge of committing an offense of rape or an attempt to commit rape, either way, even if he has committed the rape or he is attempted a rape, and there are reasonable grounds for believing that an examination of this person will afford evidence as to commission of such offense. it shall be lawful for a registered medical practitioner employed in a hospital run by the government or by a local authority, and in the absence of such a practitioner, within the radius of 16 kilometers, practitioner from the place where the offense has been committed by any other registered medical practitioner acting on the request of any police officer or for any person acting in good faith in his aid and under this direction to make such an examination of the arrested person and to use such force as is necessary for that purpose. So normally in this case, it's mostly the social stigma and taboo, etc., hold the person back. Otherwise, once it is, and that might not at all surface and come to the knowledge of a police officer, but when it comes, it has to be ensured that he's putting the right, reasonable, necessary force to ensure that person with whom the crime has been committed of a rape, to safeguard that interest of that person, the accused has to be definitely medical examined with sufficient requirement of force on him. Now, the person who is arrested in the committing the offense of rape or attempt to commit a rape. In both the cases, some or other situations like fighting, struggle mark, some kind of biological fluid which has been exchanged even during commitment, not commitment, even by the attempt of the particular or trying to attempt that offense, etc. So these are, or maybe some strands of hair during struggle. So all those things, the struggle mark on the body of that person, or reasonable whatever on ground to believe that person's examination will afford some evidence. So in that case, now if you see, the previous was a more generic section. This is now specific towards, more towards rape. So when we come more towards the rape side, then it says it has to be, mostly has to be done by a government doctor. It clearly says, and it has to be called out specifically for the rape, because it is something which is boldly, has to be boldly highlighted in case of rape, that yes, in case of rape, this is what you do exactly. And it has to be run by a government or a local authority, because there are certain kits and tools, etc., which are used, certain forms are which are used, which is the right format is available by the state government to those government hospitals. But in case if there is an absence of such a practitioner or a hospital, so within the radius of 16 kilometers from the place, within 16-kilometer radius of that place where the offense has happened, on request of a police officer or somebody in his aid, again, like previous section, the such any other registered medical practitioner can also examine the accused. Subsection 2 says the registered medical practitioner conducting such examination shall, without any delay, examine such person. So whenever the instructions are given, he has to be examined as soon as possible and prepare a report of this examination giving the following particulars. So following particulars are mandatory: the name and the address of the accused and of the person by whom he was brought, the age of the accused, then the marks of injury, if any, on the person of the accused, which might be a struggle mark, the description of material taken from the person of the accused for DNA profiling. So what all has been taken, saliva, semen, etc., etc. So those hair strands. So those things are material taken from the person of the accused for DNA profiling, and other material particulars in reasonable detail. So anything else which is believed to be, for example, blood stains in case of some injury has happened, and all those things has to be collected, and everything has to be properly labeled, marked as per the procedure, and stored and forwarded in the right manner for further biological and DNA evaluation, etc. Subsection 3 says the report shall state precisely the reason for each conclusion arrived at. So if any conclusion has been given around any of the samples taken or any of the examination taken, it has to be completely given in with a reason there. The exact time of commencement and completion of the examination shall also be noted in the. So you remember the similar situation for the rape victim also. It is very, very important that when the examination has happened, what time it has started and when time it has concluded, that also has to be registered in this case also when we talk about the accused. Subsection 5 says the registered medical practitioner shall without any delay forward the report to the investigating officer, who shall forward to the magistrate as part of the documents and under 193. So it has to come as soon as possible from the medical practitioner. It has to go to the police officer, investigating officer, and it has to go to the magistrate finally, who will have a look. So it gives again an authority for a medical examination like the previous one, but it is specifically for guideline for cases where a rape accused we are talking about. The primary objective is to take the person to the state-run hospital or a local authority-run hospital. And worst case scenario, if such thing is not available, then within 16-kilometer radius of the offense where it has happened, any medical practitioner would be utilized, but then it has to be on request of the police officer or somebody on his lead. The report requirement has also been structured here about the bare minimum requirement, what is there. But when you see the actual reports, it is actually very, very big. It is 7, 8 pages, 10 pages big report. There is a very standard performa given by the government, which is a printed form which is available in the hospitals. And the justification of the findings, every finding whichever is given, a justification has to be given because this is a matter of a life. There is, in spite of the person hold from the same situation, alleged to have committed or somebody is tried to commit the offense. In those cases also, there's always a small iota of risk that this person is not actually the same person. For many multitude of myriad different reasons it could happen. And that is why it is very, very important that such details are immediately recorded, and the justification in the biological sampling or medical test has to be given very clearly. It cannot be a vague just considering he is a rapist and we have to write anything just without any justification, because nobody has a right to say anything conclusive about an accused to be guilty. It's only the courts who can make that decision. So the every other ingredients bringing party has to just go ahead and provide such a certain evidences what is required to be extracted by them. So this also again times talks about the timelines of the documentation. It has to be done immediately as soon as possible, and it has to start and end, and that time also has to be recorded. Why? This is not only to ascertain that there is no foul play in such kind of medical test. There is a time bracket which is given there and under which it has to be done, and everything could be corroborated around that. But it is also to safeguard the interest of the victim, because until and unless you don't bring in the reports from both, you cannot go ahead with the judgment, etc. Then it talks mandatorily about the submission of the report, which makes it completely clear. It has to be rapidly happening, and the report has to finally reach the desk of the magistrate. So it's a critical evidence collection stage, which is there under this section, and it ensures a timeliness and accountability and support for a legal proceeding as soon as possible. So legal proceeding is supported with that. Now let's move to section 53. Examination of arrested person by medical officer. Now you have brought the person, is being examined. So let's see the examination of the arrested person by the medical officer. So when any person is arrested, he shall be examined by a medical officer in the service of the central government or a state government. And in case the medical officer is not available, by a registered medical practitioner soon after the arrest is made. So soon after the arrest is made, the person has to be examined by a medical officer, and he should be examined primarily by the government, central state doctor, or in case those people are not available, then by any registered medical practitioner, but soon after the arrest is made. So as soon as possible, it has to be done, provided that if the medical officer or the registered medical practitioner is of the opinion that one more examination of such person is necessary, he may do so. So in case an examination is done and they come back and afterthought and think there is some more test has to be done, that also is possible by either of the doctors. Provided further that where the arrested person is a female, the examination of the body shall be made only by or under the supervision of a female medical officer, and in case the female medical officer is not available, by a female registered medical practitioner. So when we talk about medical officer, we talk about the government hospitals. When we say registered medical practitioner, we talk about the private doctors. So in case of female, it has to be done in the, like the previous section, either by the medical officer or doctor who is a female or under supervision of them. So in law, normally we call everybody is a he, and that is why section 1, subsection 1 talks about he has to be examined. Subsection 2 says the medical officer or a registered medical uh, practitioner so examined the arrested person shall prepare the record of such examination. So a record has to be created because the whole purpose is to bring those records only, mentioning there any injury or mark of violence upon the person arrested and the approximate time when such injuries or marks have been inflicted. So this is has to be ascertained that some kind of injury or marks of violence, injury and any kind of marks of violence, any kind of wound is there, that has to be noted down, and it has to be ascertained also through the medical analysis of that particular wound that how long back this wound have been might have been inflicted on that person. Now, subsection 3 says where an examination is made under subsection 1, a copy of the report of such examination shall be furnished by the medical officer or registered medical practitioner as the case may be to the arrested person or the person nominated by such arrested person. Why this is required? This is required to ensure that the person's rights are not violated about up to the extent of the medical investigation also, because he knows about the offense, he knows about the grounds, etc., why he is arrested. But then he should also know what is the result of the medical examination also against him so that he can safeguard himself, his position as much as possible. So it's a mandatory medical examination what we are talking about. It has to be examined by a medical officer, by a central government or a state government hospital, or by a registered medical practitioner. And we know from the previous chapter, it has to be done on request of a police officer or a person or to his aid. So this provision basically allows the additional examination should the medical personnel believe it. If they want, they can do one more additional medical examination also. So this allows any medical concerns that are adequately, because it might happen that a medical examination is done by one of the doctors in the government hospital. He has come up with some other conclusions, and that has gone to the senior medical officer there, and the senior medical officer with his experience has come back and recommended some more tests has to be done, or probably some test has to be redone, because we know from the previous sections we have read it has to be issued by the doctor there, but then it is in practice it has to be gone through the eyes of the CMO, the chief medical officer in that case. Or in case some other information is brought in and there is a in lieu or in regard to that particular information, some other test has to be done of the accused to ensure that those angles are also verified. So in that case, if they want, they can do those things. Requirements for a female examination is also clearly mentioned in this section also. It's similar. And documentation of the finding, as usual, has been emphasized. It has to be documented. And the distribution of the report towards the accused is also mandated in this section to ensure that accused rights are also saved, the protection of the right of accused also safeguarded, while the evidence collection is also happening, and there is a gender sensitivity. Let's go to section 54 now. It says identification of person arrested. Now, this is a very, very important stage, and this has got a lot of international implications also. When a person is arrested on a charge of committing an offense and his identification by any other person or person is considered necessary for the purpose of investigation of such offense, the court having jurisdiction may, on the request of the officer in charge of a police station, direct the persons who are arrested to subject himself to identification by any person or persons in such manner as the court may deem it, provided that if a person identifying the person arrested is mentally or physically disabled, such process of identification shall take place under the supervision of a magistrate who shall take appropriate steps to ensure that such person identifies the person arrested during the using the method that person is comfortable with, and the identification process shall be recorded by an audio, video, electronic media. So this is a step of identification of the person arrested. So at times it is very, very important. In fact, in every time it is important to have the identity to be secured of this, securely verified of that person, that this person is the same person who has to be arrested. So the person whom we have arrested is the right person. But there might be special cases where the when a person is arrested and are charged of committing any kind of offense, his identification by some other people is necessary. For example, in case of bank robberies, in case of theft, etc., you bring in those people and do an identification parade to ensure that the persons who are brought in are really allegedly the same persons who were arrested. In case of rape, also this might happen. So, uh, on the request of an officer in the charge of police station, the court who is having a jurisdiction can allow that and direct the person to arrest to subject himself to identification by any person or persons. So one person or multiple persons can do that validation. There is a proper process for that, and as the process and the court may deem fit, and provided that if the person who is identifying is mentally or physically disabled, so somehow the person is mentally or physically disabled, in that case the identification should be placed under the supervision of a magistrate, because these are sensitive situations. The person has to be identifying the person depending upon how they are comfortable, and that has to be taken care, and that guarantee is asserted by bringing a magistrate in picture. And as this is a special scenario where there might be later disputes arising, a person who is a firm, who is fine, who is healthy, who is somebody who can communicate well, who has a right locomotory and various other capabilities. If that person, if is in a good mind and health and etc. etc., his statements, his identification is trusted. But in case of the person is not of the firm mind, or for some reasons he is not physically fit also, in those cases it has to be ensured that the magistrate is looking into it. But audio video recording is also very, very important, so that tomorrow there cannot be a second opinion alleging that that person actually did not recognize that person, and uh, some other kind of information, or some other kind of expression was given by the person which was misunderstood as a clear identification by the police at that point of time, or the magistrate. So on top of that, it has to be recorded also in audio video both. So this is a court directed identification what we are talking about under this section. So it establishes that if the people who are arrested, their identification is necessary, the court may order the arrest person to undergo identification by witness or anybody else. And this provision is essential for corroborating evidences and confirming the identity of the person who is connected in relation to that crime. Roles of the police officer here is that the identification can be requested by an officer in charge also of the police station, who is facilitating some kind of uh, communication between this law enforcement and the judicial system, which is an investigating officer or a senior police officer of that police station, or a sub-senior officer, to advance investigations effectively. So the person has been arrested, then this person, if is identified, it reinforces the position of the prosecution also, that yes, this was the person who was there, who was committing that. And there is a judicial discretion which is added in case of the permission has to be given for such court directed identification, or in case of the person who is not of a firm mind or body, those persons could be have a judicial supervision, while the judicial discretion is given to determine the manner of the identification, so that the process is conducted appropriately in a way that is deemed suitable for the circumstances of the case. Now, it accommodates for the disabled individuals, as we have seen, and it uses technology also is something which is included into it as a requirement, where audio video recording is also allowed and mandated in case of special cases of people who are of not a firm mind and body. So this is a very strong support for the investigation. It protects the vulnerable individuals also. It gives an enhanced transparency as well. So that is what is Section 54, which also helps to identify the arrested person when necessary for the investigation of a crime. Section 55 then says, procedure when police officer deputes subordinate to arrest without warrant. So we are talking about a situation when a police officer is bringing a subordinate in picture who has to go and make an arrest. We talked about it at the very start of this today's lecture about the arrest without warrant, where the police officer is doing it. But here we're talking about the same scenario when the police officer is deputing a subordinate to arrest. So subsection 1 says, when any officer in charge of a police station or any police officer making an investigation under Chapter 13 requires any officer subordinate to him to arrest without a warrant, otherwise than in his presence. So if he's standing there and he's asking somebody to be arrested, it is as good as he is himself doing it. But in case if he is not standing there and the person has to go by himself and the person has to make an arrest without warrant, then this section is applicable, that any person who may lawfully be arrested without a warrant, he shall deliver to the officer required to make the arrest an order in writing. It has to be an order in writing which has to be given, specifying the person to be arrested so that the right person is arrested, and the offense or other cause for which the arrest is to be made. So the officer who is going to arrest on behalf of the subordinate also has to know exactly on what kind of offense that particular person is being arrested, and any other cause for which the arrest is to be made, and the officer so required shall, before making the arrest, notify the person to be arrested on substance of the order, and if required by such person, shall show him the order. So basically, it is coming back to the same part where we are identifying, explaining the person that exactly for so and so reason you are being arrested. And in this case, as there is an order which is engaged, irrespective of there was what communication has happened verbally. So there was an order, written order given to him, and he can go back and show that order to the person also before making an arrest, saying that you can read, I've been authorized for so and so reason to arrest you. And this is very, very important that the police officer who is going to arrest, he has to be specified the person to be arrested in the offense or the other cause for which the arrest is being made. Because it is not only very, very important for the sake of the knowledge of the police officer, it is very, very important for the sake of safety of the police officer and to efficiency of the police officer also. If the person is not aware that the person whom he is going to arrest keeps firearms, and he has been doing the same thing by showing and pouncing on people to shoot, etc., he might be putting his subordinate's life at risk, or probably some other substances which the person holds, he might not be able to understand and make the search of the person or the place where the person is to ascertain those things are also taken along with him. So all those things, these are just two stray examples. That could be n number of numerous examples depending upon case to case, but then officer has to be made completely aware of whom, where, why of the arrest, and in a written order. This order, then the subordinate can pick up and execute. And while executing that, the person has to tell about the offenses, the grounds of arrest, and if it's a bailable, non-bailable offense, and what are the vitalities which could help him to gain his freedom. And if required, he can also present the order for inspection to such person as well. This is just to show him that order. Subsection 2 says, nothing in subsection 1 shall affect the power of a police officer to arrest a person under section 35. So when we talked about this particular part 1, where the person can go ahead, he could be deputed to make an arrest, etc., etc., nothing under this section is avoiding him to execute his powers to arrest as under section 35, which is the first section in the arrest of persons, which when police may arrest without warrant. So wherever such powers are given to the police officer, so it is something cannot affect the power of a police officer to arrest a person under section 35. So the person's power is also Section 35, which is not affected by this section. Nothing is stopping that. So it's a written order for arrest to a subordinate, which has to be given, which has to give a complete picture of the situation, why the person has to be arrested, who has to be arrested, where from the person has to be arrested, and why the person has to be arrested. And this is something which has to be given on writing, so that it is also causing an accountability to the person who is delegating it to his subordinate, so that it is justified on the legitimate grounds. Notification to the person of arrest is a basic requirement as per given by the constitution, and everybody needs to know why they have been arrested, where they have to be taken, their relatives has to know, their friends has to know. So all those requirements are still has to be completed. And preservation of the arrest power. So this is something clarifies that the delegation will preserve the power of the arrest. So even if for some reason the officer is not able to do it, he can give it to subordinates. Say, for example, the officer has to make three arrests in three different areas in the same day. He cannot be in the three places at the same time. He can delegate it to some subordinates to some places, and some places he might visit. So that is why it preserves the arrest power of the officer by even by delegating the same to the other officers, but then he has to ensure taking an accountability that the complete picture is known to the person who's going to arrest, and this is accountability and transparency has to bring in, and a prevention of an arbitrary arrest also happens, so that the person may just not just call somebody subordinate and say something verbally out of something in his mind which is not something which is accountable for, and the subordinate does an arrest, and by the time the situations are so worse against the police who is making the arrest, the there is a problem in the law enforcement in that case, and then it is something which is arbitrary arrest which could be promoted if it is not done the way it is being done in this section. So it brings also a flexibility in the law enforcement, because it can be delegated and flexibly used or executed parallel in the parallel time. Let's say see section number 56, which is health and safety of an arrested person. So it shall be the duty of the person having the custody of an accused to take reasonable care of the health and safety of the accused. So it could be a police officer also, it could be a private person also. The person has to be carried properly, safely, using the required number of restraint and force. And the person's health and safety also has to be taken care. The person cannot be tied behind a jeep by a private person or a police and then make him run with a running jeep, or being dragged with a jeep and taking to the police station. Those things are not allowed. So that is something, health and safety of the arrested person has to be taken care by the police. And this is a duty of care which comes in. So duty of care is something, is a very important famous term in the subject of tort also when you study. So it is a duty of care which is brought into the context of the criminal laws in terms for applicability on the person who's making an arrest. Because why he has to do a duty of care? Because the person who is being arrested or detained by him is somebody who is helpless to help himself or care himself. So he has to be provided a care as well, and that is why the duty of care is which is established in this particular section for the individual who have a custody of an arrested person to ensure the reasonable care. You need not bring it to an air conditioned room to take care of his health if he's used to it, or maybe such kind of things. You have to do the bare minimum to ensure a reasonably a person would be staying healthy and safe in that environment. And this is a duly encompass in ensuring that the arrested person is provided with adequate medical attention also, if required, maintaining the physical and mental well-being and protecting them from harm during their time in custody. So that is why if required a medical attention, that also has to be provided. And it's a legal and ethical requirement as well. So the law enforcement, legal and the ethical standard for law enforcement and custodial situations, it is an accountability of the treatment of the individual in their care, and thereby promoting the humane and just treatment within the criminal justice system. So it has to be a human way of working in the criminal justice system. So the law enforcement agencies here and the custodial facilities are has to be implemented and use cases in such a way that the health and the safety of the people in custody has to be taken care, which is their obligation, and including training staff on how to support the physical mental well-being of an arrested individual. This duty also is something which is a necessity for appropriate facilities and resources to be provided so that the medical and the psychological support is also given to the accused. As I said in the previous discussion, the accused is a person who is tagged to have somebody who has committed the crime. He is not the guilty until now, and could be any by any imagination could be the person who is actually not done it. So this is a protection of right of an accused, accountability of the mechanism which is set, and a public trust which also generates by such practices. So this is about section 56, which is bringing the duty of care and ensuring the health and safety of the arrested person, health and safety both. Now let's go to section 57, which is person arrested to be taken before the magistrate or officer in charge of police station. So whenever arrest is happening, it has to be taken to the magistrate or an officer in charge of police station first. So the police officer making an arrest without warrant shall, without unnecessary delay. So unnecessary delay is defined. What is a necessary delay then? It might be the time when the person is in transit from one point to the police officer or to the police station in charge or to the court, or for all whatever reasonable reasons. So police officer making an arrest without unnecessary delay and subject to the provisions herein contained as to bail, take or send the person arrested before a magistrate having jurisdiction in the case, or before the officer in charge of a police station. So he has to bring it to either of them. And this is something which is talking about a timeliness of the presentation of the accused to either of them. So it is a primary mandate under this section that the police officer who has made this arrest without a warrant and send the arrested person before a magistrate or the officer in charge of the police station without unnecessary delay. And this provision is essential to protect the rights of the arrested individuals and to uphold the principle of justice, ensuring that the individuals do not languish in detention unnecessary without timely judicial oversight. So judicial oversight is required. There is no right of the police or any law enforcement agencies to detain somebody just for the sake of detaining and forgetting. Liberty is a right which is and the fair judgment justice is a right given to every person on the land, and in that case it's not really allowed to have a detention which could be which could be forgotten. So it is very, very important. If a person, as we have spoken yesterday also, if an arrest is happening, if a person is being arrested by a police officer even without warrant, even by being left on a bond or a bail bond, etc., etc., or being presented to a magistrate before being released, whatever be the case, the very first thing is this machinery has to move responsibly. And if it has moved responsibly, which means something which has happened, which was meaningful in the eyes of the law and it was correct. In that case, it was discussed yesterday that it is very, very important. In that case, there is a record to be created because you have done something legible and which is something which is legal. Then there has to be definitely a record of it, which they have to present to various forums. But in this context, if we see, it means it has to be, if it is done in a fair way, it's a rightfully done by the police authorities or any such kind of authority, any kind of agency, then it is why can't it be said then it has to be immediately bring into the ambit of the judicial oversight, because the role of the police finishes from the purpose where the body is secured, the person who is arrested, or the situation is diffused, such arrests have been made, such recoveries had been made, etc., etc. But then after that, there is no role. They are executors. They have certain autonomous execution rights given for the sake of the law and order, but mostly they have to execute certain things, and they are then responsible to bring it under the ambit of the judiciary to further process that situation. So that's why a timeliness of the presentation is something which is very, very important and part of this particular section, which says the arrest without warrant shall, without unnecessary delay, he has to bring in an authority of a magistrate or a police officer it has to be brought in front of them. Because why? Because if the person has to be brought in front of the magistrate, please remember we have spoken earlier about it. It does not matter if the magistrate uh, uh, is somebody who is out of the jurisdiction also, if there is no option. But primarily this section talks about a magistrate who has a jurisdiction over the case. So in that case, if a case is running and the magistrate has a jurisdiction in the case, then he has to be brought in front of that particular magistrate and for the appropriate legal proceedings. The person has been arrested, brought to the magistrate. Alternatively, they be taken to the officer in charge of police station, and if he deems appropriate under 189 BNSS, he can take a bail bond himself and let the person go. Or under 190, he can let the person being uh, forwarded to the magistrate. So it's the authority of the magistrate or the police officer. In the case of magistrate is when the jurisdiction over the case is there already, or if police officer in case it's a fresh arrest and the person has to be, it's a police officer who decides, the police station in charge, that whether he can be released on a bail bond at his level or the person could be, has to be forwarded to the magistrate to take his cognizance. And depending upon it's a bailable or a non-bailable offense. Normally in the bailable offenses, the police officer cannot take a discretion of releasing the person. If it's a non-bailable, he has to send the person to the magistrate. And the consideration of the bail provision is also which is considered under this section. So this means a prevention of an arbitrary detention because the person is immediately forwarded and not blocked at the stage when he is arrested. He is not vanishing there. The judicial scrutiny is also there because it is coming to the magistrate and finally through the police officer also. Either the record of his bond or his presence is being registered in front of the judiciary. And there is a clarity on the law enforcement in case if they arrest, then what they do. What is the next step they have to do? So that is something which brings in the accountability in the case of the police officer making such arrest. So, and in either way, if it's a jurisdiction of the case is with the magistrate, of course it will go to the magistrate. Otherwise, under 189, if the police officer finds it's a non-bailable, there is not much evidence, the person is arrested on without warrant, he can release that person also completely. Now, coming to section 58, which is the last section in first set of sections under chapter 6, rights of the arrested person, 47 to 58 we were seeing. So section 58 says person arrested not to be detained more than 24 hours. That's a thumb rule. So officer in charge of police station shall report to the district magistrate or if he so directs to the sub-divisional magistrate, which is SDM, the case of all persons arrested without warrant within the units limits of their respective stations, whether such persons have been admitted to bail or otherwise. So the detail has to be given. We talked about it detail in the previous video where you can go back and have a look. So it talks about the time limit of the detention, that the fundamental principle is to that no person arrested without warrant can be detained for more than 24 hours. And this provision is designed to protect the individual's right and also prevent the arbitrary detention of individuals, ensuring that they are either formally charged and remanded to the custody or released with a reasonable time frame. And an administrative oversight is also there. And there is a reporting is also very, very important because of that. So it provides a clear oversight on the what legal procedures are being followed. It keeps the judicial authorities informed about the status of the detainees, etc., etc. And there is a contrasting difference between the jurisdiction of the district administration and the police administration. Police administration is normally something which is a subject where they have to keep looking into the crimes happening, prevent it, or whatever action has to be taken in that area. While the district magistrate looks into that as well, on top of that, they have to bring in such measures so that the society in large in that jurisdiction is also being monitored for such kind of demographical increase or decrease of crime and work on such plans and procedures to decline that in society. So they have a wider perspective from the district administration perspective. They don't have only punitive perspective. They have also from the perspective of ensuring that this is something which is helping the social makeup of that particular district, a healthy one, or some permanent measures, law, the rules, etc., has to be then suggested to the relevant parties. So this is a application which is a section which is applicable to all persons which are arrested within the jurisdiction of the respective police station, regardless of these individuals have been admitted to bail or they have been left, etc. So it ensures a comprehensive recording to the district administration. Also, as I mentioned yesterday, also the police seniors and the leaders, the head of the police department, etc., already have a visibility to that. That's why that is not mentioned here. So this is a protection against unlawful detention, which is secured by this section. It is an increased accountability and a judicial oversight, which is given. Now let's move to the last subject, last topic of this particular chapter, Constitution of India, Article 22. So Article 22 basically provides what? It provides an important safeguard against the arbitrary arrest and detention of the individual. It outlines basically the rights of the person who are arrested, ensuring that their fundamental rights are protected during the legal process. And the key provisions of Article 22, which is related to the rights of the person arrested, it could be summarized as number one, the Article 22(1) states that the right to be informed on the grounds of arrest. And that is why, on the framework of the Constitution, such sections are configured, which we have seen today in the section in the chapter 6 from 45 to 58, 72, 70, 78. So Article 22(1), the first part says that every person who is arrested shall be informed as soon as maybe on the grounds for their arrest. And this provision ensure that the individuals know why they are being detained and safeguarding against unjust or arbitrary arrest. Until you don't know for what reason you have been detained, you cannot go and start practicing for that offense, from safety from that offense related detention. So right to consult and be defended by a legal practitioner, which is also given under this article, and it guarantees the right of the arrested person to consult and be defended by a legal practitioner of their choice, which is something which is also instructed and guarded by this particular article. And the person has to be produced before a magistrate. If you see, everything is which is converted from this article back to the section that the person arrested, detained should be brought in front of the magistrate within 24 hours, and protection against the detention beyond 24 hours is guaranteed. The special provisions to prevent any detention which is given here is the subclass A states that the right mentioned above do not apply to any person who is an enemy alien. So there is a case of a exception which is also given, and providing that do not apply to any person detained under any law providing to preventive detention. So regarding preventive detention under law, if it is done, then this is not which is applicable, that is a procedural detention. That is not because somebody has been caught doing something. It has to be is a planned and a preventive detention to avoid something to happen. So that such detention must be reviewed always by a authorities in under specific period, and usually 3 months, to ensure that the detention is justified. So even if in case of the exception, every 3 months it has to be reviewed that is it still necessary or is it still valid. And the right to representation, again detention, which is a very important right called upon by the Article 22, is when a person is detained under preventive detention law, they have the right to communicate the grounds for their detention as soon as possible, enabling them to make a representation against the order also. They also have a right. So overall it safeguards the individual rights. It gives an access to the justice by knowingly under what provision and sections they are arrested, on what grounds, and there is an accountability of the law enforcement also, which is provided by Article 22, by safeguarding the chance of defense to the person. So that's about the Constitution of India and Article 22, the high level, whatever is the reason, which is in connection with the rights of the arrest person. And we now move to chapter 7, which is preventive powers of the police, which is section 168 to 172. It is a complete chapter, which is chapter 12, which is called as the preventive action of the police. So police has multiple roles. One of the role is a preventive role. So police can not only is expected to be in action only after something has happened. There is a preventive role, there is a social role, etc., etc. So one of them is the preventive role of the police, which is chapter 12, which is inclusive of chapter 168 to 172, all of them. So 168 says police to prevent cognizable offenses. So every police officer may interpose for the purpose of preventing and shall, to the best of his ability, prevent the commission of any cognizable offense. Now, this is something which is a primary role in this direction of a police officer, where it's a proactive duty of a police officer to ensure that it is obliged that they are, this is obligated that they are they are preventing the commission of a cognizable offense in front of their eyes, and this establishes a proactive duty of them to engage in measures that deter crime and protect citizens. There are multiple case laws around this, which talks even about, irrespective of the actual jurisdiction of the police station or the department they belong to, it is okay if they see such cognizable offense happening in front of their eyes out of jurisdiction also, then also they can act on this. Definition of a cognizable offense is very well given in the IPC, and even CRPC has a schedule around that, but the cognizable offenses are those that are serious in nature. Basically, these are serious crimes and allows police officer to arrest without a warrant. They are allowed by law to arrest without a warrant. We have talked about some scenarios where we said, we in previous sections in the previous chapter, arrested without a warrant, it might be a mixed scenario. But in this situation, when a cognizable offense happens, it's a serious offense, there is an authority 100% given to the officer to make an arrest without a warrant and initiate an, because that situation itself is warranting the arrest. So, and initiate an investigation without direction of a magistrate. They can initiate it. Where they cannot do it in a non-cognizable offenses. We have seen that in non-cognizable offenses, the police officer cannot initiate an investigation because there is a strong bar on that. In case of a non-cognizable offense, if it happens in front of the police officer, he may stop the person. He may ask his address and whereabouts, his identity. If he is fine to give, it is okay. The person will be released. Otherwise, he will be arrested and presented to the magistrate in that case also. So typically example could be serious crime like murder, rape, robbery, and other violent acts. These are all cognizable offenses. And this is something which is very important, that the cognizable offenses are taken seriously. Then this section talks about the scope of the duty of the officer, where it says to the best of his ability. It says to the best of his ability, which means the police officer are expected to take reasonable and appropriate action within their capacity to prevent cognizable offenses. This includes employing methods such as patrolling, community engagement, surveillance, responding to the potential threat to public safety. So it's not always that the person, when it means that the cognizable offense, they're allowed to act, any police officer, every police officer may interpose for the purpose of preventing and shall, to the best of his ability, prevent the commission of any crime. It does not mean always that the police officer is passing by and two people are, having a gun, shooting on people, and then he jumps like a hero and he then fights with them and gets the gun in his custody and then shoots the two criminals in the head. No, the situation has in a broader perspective. So the scope is to the best of his ability. So the best of his ability is not only the ability to fight an encounter. That is the last thing. What is more important is to stop that cognizable offense. What all they can do is they can do a patrolling. Sometimes you see there are some police vehicles which are parked at certain places with their beacons, etc. All that is also the best of the abilities. They are setting up a situation where deterrence is created by just just denoting that a presence of the police officer is there, or there is a bike patrolling, the jeep patrolling. That is also, which is the best of the ability to ensure by the police officer in charge of that police station, to ensure that the cognizable offenses are avoided. And probably surveillance also, if there is some kind of intelligence department or some kind of LIB or detention branch, etc., detection branch, etc., DB, they do surveillance. And by surveillance, they look into the potential upcoming problems and they do take those proactive steps to stop that, and responding to potential threat, which we talked about, the Philby situation. So empowerment of a police officer is done by this, and it is also asking them to come back and present all the abilities in spite of only the fighting or the their raw acting abilities. So this is something which is a uh, to be done to avoid any cognizable offense. Even some kind of social kind of gathering is also something which is a deterrent to crime. For example, the senior citizen meetings, which is done by the police, will also give to the a message to the people who might go and create problems and hurdle for the senior citizens, to ensure that they will not do it, because the police is continuously talking to them. And then there are certain people who are brought by some legal experts, etc., brought to them, who might be also consulting them. So that is also a deterrent. Or the school visits by the police kaka or by the daminis, etc., what happened. That is also something which is very, very important, where a deterrent, works as a deterrent to the cognizable offenses, where any school student to student or of teacher to student, such kind of harassment, sexual harassments, etc., would be a deterrent in this situation, and this is nothing but a cognizable offense which is stopped before it happened. So this is why this section says they have to be to the best of his ability. So this, the most important section part is to his best of his ability, which anywhere you want to describe is to pick up that line of discussion for this section. And this is a crime deterrence, which is the role of this section. And a public safety is automatically enhanced when the police officers are working to best to their abilities. And the responsibility and accountability is on the head of the police officer to act in all the ways which is possible to best of their abilities. Let's move to section 169 now. Information on design of to commit cognizable offenses. So what is the design of commit offenses? The plan of the offense. So any kind of information of design of to commit cognizable offense, when it is received, then what is the section says? It says every police officer receiving information of a design to commit any cognizable offense shall communicate such information to the police officer to whom he is subordinate, which is the police station in charge. And probably if a constabulary is there, they will report it to their PSI and ASI, etc. And to any other officer whose duty it is to prevent or take cognizance of the commission of any such offense. Or if they see, for example, some narcotics activity happening, so they have to also go back and inform the narcotics department. If there's some kind of design of crime is of some kind of bomb blast, they have to go back and talk to the bomb squad as well, and all to the senior officers, DCP, ACPs also. So all this is given in this section, that it is the moment they receive it, information of such a design, it has not still happened. It is still in the stage of inception or planning. They shall communicate such information to the police officer, to his subordinate or any other police officer, to prevent that or take cognizance of the commission of any such offense. So this is an obligation to communicate information which is given by this section. So this is nothing but an obligation to communicate. Is the police officer acting on it? No, he has acted in the previous section. In this section, he is a messenger. In this section, the police officer has not acted. He is working as, he is complying with his obligation to communicate that information. And once he is aware, he has to give it to the right stakeholders immediately, that information, so that the right prevention of the criminal offense happens. And this is following the hierarchy and the reporting, and it has to be hierarchy in terms of his senior or junior relationship with his to whomsoever is subordinate to, or it has to be a reporting to the right officer, right department. If it has to be done that way. So communicate to the relevant officer, which is very, very important part of this particular section. And why this is required, this communication, the sole purpose of this whole of the communication and the role of the messenger, what the person is doing is to preventing such kind of any kind of such cognizable offense for which some kind of plan is already being made or prepared or is already ready. So it enhances a vigilance. So this is a vigilance role of a police officer, where he is vigilant and he is looking around, and he is reporting also, not only acting due diligence, not taking a due diligence and acting. He is also in a role of reporting also, and he can collaborate among the officers and the department also, and he takes an accountability and responsiveness of, he is keeping his eyes and ear open, and when the information is received, passing on immediately for the sole purpose of avoiding any cognizable offense to happen. Let's move to section 170, arrest to prevent commission of cognizable offense. Now, a police officer knowing of a design to commit any cognizable offense may arrest also without orders from a magistrate and without a warrant, and the person so designing, if it appears to such officer that the commission of the offense cannot be otherwise prevented. So in the situation where the police officer who is knowing of a design. Now, this is a little different than the previous one. The officer is different here. Either similar or a different, either the case. So, either the person, officer who has communicated, if it's in his possibility, huh? So that person himself, or if the person who has communicated to the other officer, now that officer, the police station in charge or a senior officer is also aware. So either of them, if they are aware of the design to commit any cognizable offense, and if they believe there is no other option than quickly jumping ahead and arresting the person, they can do that without any order for or a warrant without a warrant or an order from magistrate, because if that is something which is going to prevent the and there is no other way to stop that commission of that particular offense. Now, if for example, if somebody is doing a patrolling in the night time and this happened in the Khadki and they had they see people taking out the stones from the railway track for the sake of utilizing it in their own personal construction, and that those marshals immediately respond on the walkie-talkie. They make that communication immediately under the previous section. They work as a informant in that situation, and they make the right set of people through the walkie-talkie and to the control about the situation. Because if 15 people are standing there, 10 people are standing there, it's practically impossible for the two people to be a deterrent to such people, although they will try. But for the complete stoppage of that, they need a force. So in that case, they communicate, but in the moment the police force comes behind them, two, three more people come, they cannot now go back and say, you stay there. I'll get a magistrate order and then I'll get a warrant issued, then I'll arrest you. No, in that design of offense which has happened, and which is for which the people are standing near with all the machinery and everything, and they are planning to extract the stones from the track, which might cause an accident. The only way to stop that design of the crime is to immediately go and take an action. So this is one example. There could be many. And subsection 2 says no person arrested under subsection 1 shall be detained in custody for a period exceeding 24 hours because it has been arrested without a warrant, unless his further detention is required or authorized under any other provision where the magistrate will is the only capable to order that, not even a police officer or a police officer in charge. We have studied about this earlier. So this is a authority to arrest without warrant if there is no other option to stop the execution of that or the prevent the commission of that particular cognizable offense for which a design was detected in under section 169. And the criteria of arrest is that the arrest can only occur if appears to the officer that there is no otherwise an option to prevent the commission of this particular cognizable offense. And this clause ensures that the power is given amply to the police officer to exercise it judiciously, but then use it in the time when it is very, very important for the public safety or the safety in general. So there is a limitation on detention. By default, it is counted by the previous sections where when we talk about the arrest without a warrant, detention cannot be exceeding 24 hours, which is automatically operative in this particular section. And from all the previous sections related to the same, we know also that the extension of the detention can only happen by the order of any magistrate. And that also we have studied that in case of the detention happens, even if a magistrate is of no jurisdiction of that particular area or matter, that magistrate can also take a decision on the detention if it is required for any kind of investigation and to support the cause of the law. So this is a preventive policing which is required, and this is protection of the rights of the relevant individual that also cannot be kept in detention for more than 24 hours in spite of they being arrested for in the preventive policing. And this is a judicial oversight which is added automatically after 24 hours when the persons are arrested. Move to section 171. which is prevention of injury to public property. A police officer may, of his own authority, interpose to prevent any injury attempted to or committed in his view, to any public property, movable or immovable, on the removal or injury of any public landmark, buoy or other mark used for navigation. So this is the wordings are old English wordings. So this is a law enforcement's role to prevent any kind of public property damage to be prevented. So it is a responsibility that the law enforcement to protect the community asset and maintain a public order. So when we see this section, this talks about the these kind of authorities, police and the other law enforcement agencies, their role to ensure there is a safety which is brought into the public property and maintain the public order. So it talks about a proactive authority. This is a proactive authority given to the law enforcement agencies like police, and police officers has the authority to act on their own initiative. It is a very important thing. They can act on their own initiative. When their own initiative is given there, it's their own personal understanding also they can act reasonably. Of course, they're answerable for that. But authority to act on their own initiative to prevent any act of injury or damage to public property. So in the previous section, we talked about, previous to previous, we talked about they are going ahead and being an informant to the situation, they're informing. But in this situation, an individual police officer not needing to talk to his senior or any other person or a magistrate is on own initiative to prevent any act of injury or damage to public property that they observe. And this empowers that officer to take immediate action. They can, sometimes an action is required as a reflex at that immediate moment. So they cannot even pick up a phone and ask somebody to take immediate action to protect both movable and immovable public assets, such as building, infrastructure, monument, buses, trains, etc. What is the scope of protection? Is broad in this application, which covers all type of public property. So any public property could be covered under this one. And this includes not only physical structure, but also significant landmarks also, or navigational marks, etc. also that are essential for public safety. So if there is a board at the side, which is a board put by the traffic department or by the PMC, in our case, any municipal corporation, to go ahead and mark certain areas to be, there is a speed breaker, there is a turn ahead, there is a ghat ahead, etc. So those navigational mark, etc. is something which is very important for public safety because they are there for that reason. So that is also under scope. And by encompassing various forms of public property, the law ensures that the comprehensive protection against vandalism and damage against any such property. Or, for example, some huge TV screens they put, the PMC or the PCMC or many municipal corporation on the street for certain displays. All those are public properties. The poles, the lines, the telephone related connections, etc., etc. So this is something which is preventing on the spot in presence of the police officer, preventing of that kind of crime and to avoid such damage. And this is to also maintain an order. So it is something which is saving the public property, the public safety, promoting a civic responsibility also of the people by intervening and stopping them to do something which is other way around, and empowers the law enforcement that way. Section 172, which is the last section in chapter 7, which says persons bound to conform to lawful directions of police. So all persons shall be bound to conform to the lawful directions of a police officer given in fulfillment of any of his duty under this chapter. So if under any duty, any police officer who is asking you to do something, you are bound to follow that. You have to bound to respect that, the lawful direction of the police officer. So he just cannot ask you to do anything in any scenario if it is something which is part of his duty and is asking you to do it, which is, for example, if there is a simple example, let's take a simple example. There is a traffic which is being blocked for some reason, maybe some kind of movement is happening, and the police officer under the duty of this particular chapter He's doing his duty to block the traffic under a certain area, and he gives a lawful direction to you to stop from that signal and don't go beyond that. So then you have to abide by that. So a police officer, for example, puts a line there and says, do not cross the police line. There is an investigation going on for so and so reason. You are bound to follow that. So a police officer may detain or remove any person resisting, refusing, ignoring, or disregarding to conform. Now, you please understand very interestingly, it is also ignoring is also something which does not save you from committing that crime. So it cannot also be a defense. So if somebody is coming and saying, I ignored it by mistake, they have to really go back and prove that it was by mistake. Otherwise, ignoring also is a crime in this particular area. So resisting, refusing is a direct saying no, or ignoring, just being irresponsible, or disregarding to conform. You do whatever you say, I'll do just the opposite. To any direction given by him under the subsection 1 may either take such person before a magistrate or in petty case release him as soon as possible within a period of 24 hours. So the person will be then either has to be taken to the magistrate if there is something very major which has happened. For example, a lady had jumped the cordon of the one of the minister and she has gone and dashed with the car, which in turn caused multiple vehicles to collide of that particular VIP. That is the situation. It's not a petty offense. In that case, the lady has to be presented to the magistrate. But then there is a situation where somebody, just unknowingly or by mischief runs just little further, and then on shout of the police officer, then he leaves his, you know, disobedience and comes back, or maybe is holded by the police officer by hand there, and then he's brought to the police station. This is a small petty offense. If the person is having no criminal background, no chances of him being doing something serious, actually, it was just his simple stupidity or mischief. That person would be in a petty case, could be sent up to within the period of 24 hours. He could be. Why 24 hours is the scale? Because nobody could be detained beyond that. So normally police officers keep them for 3-4 hours, 5-6 hours, and then person is left. So this is a discretionary power of the police officer to detain in case of petty or a little higher level of offenses. So this is an obligation to conform by the people when a police officer is legally asking you under his duty to abide by something, and you are obliged to follow that. This is very important, which is by law, by force, it is creating a cooperation between the police and the public, or the law enforcement and the public. So there should be a regard for the law enforcement and the public, and that is something which is established by Section 172. It establishes that particular through the particular section. And then police has been given authority to detain or remove that person. So the police might pick up that person, put him in a gypsy or jeep, and make him, remove him from the vehicle at maybe 5 kilometers away, 10 kilometers away, and the person has to take some other route to come back, or they might detain the person, or they might detain and send him to a magistrate, or they might detain him and leave him within 24 hours to go back from the police station. They are released. So there are options given for non-compliance, which is the law promotion of the law and order is established by this, and it empowers the police officer in case of such small offenses also by giving the directions. If you see, the directions are coming out from all the previous sections around that, and that is what is the empowerment of the police station, a police officer given under this section. And this also takes care of the rights of the people also, because they are not being detained for unlimited time, and for petty offenses they are not sent to the magistrate, only for the sake of the purpose of the level of the mischief what has been done. The police officer can act that way. Now with this we move to chapter number 8, search and seizures, section 49, 96 to 110, 185 to 186. So section 49 is one section which is coming out from chapter 5, which is arrest of persons, while section 90 to 110, which is coming from chapter 7, process to compel the production of things, while section 185 to 186 is chapter 13, which is something information to the police and their powers to investigate. This is related to that chapter. So all these three chapter related sections complete chapter 8, which is search and seizure. Search and seizure can happen, discussion can happen with these sections. Section 49 says search of arrested person, where whenever a person is arrested by a police officer under warrant which does not provide for a bail, etc. We have just studied this section under chapter 6. So we know that the person, in either case, when the warrant is, or the arrest is definite, and the person has to be searched, the articles, everything has to be brought in the safe custody, and that has to be, a list has to be made. In case of a female officer has to do the search, but under the limits of the decency. So we have studied only this in just this session only. So we'll not go beyond this in section 49. I'll further move to section 96 to 110, because 49 is already part of this video only. So section 96 says when search warrant may be issued. When a search warrant can be issued is where any court has reason to believe that a person to whom a summons order under section 94 or a requisition under subsection 1 of section 95 has been or might be addressed will not or would not produce a document or things as required by such summons or requisition, or such document or thing is not known to the court to be in possession of any person, or the court consider that the purpose of any inquiry, trial, or other proceedings under this Sanhita will be served by a general search of or investigation. So this section says when a court believes that when the person whom a summon order under the section 94 is already issued. So if that summon is already issued, or under section 95 under subsection 1 of section 95, which is if any documents, parcel or thing in the custody of a postal authority is there, or in custody of any person is there under section 94. So it not might be addressed until and unless that particular thing required by the court has to be will not be recovered in other way, or such document things is not known to the court, and the court just want to the such document or thing is not known to the court to be in possession of any person. So they don't know if the person is having that. A search is which will explore and which will fix prove that, and also discover that particular material, and or in the condition where the court considered that the purpose of an inquiry, during an inquiry, the trial or any other proceeding under the Sanhita, it will be the search and the inspection will help. In all such conditions, a search warrant could be issued, and the person to whom such warrant is directed may search or inspect in accordance therewith and the provisions hereinafter contained. Subsection 2 says the court may, if it thinks fit, specify in the warrant the particular place or part of the place thereto which only the search or inspection shall be extended, and the person charged with the execution of such warrant shall then search and inspect only that place or part of that place. So see how much it is bracketed, very specific. And subsection 3 says nothing contained in this section shall authorize any magistrate other than a district magistrate or a CJM to grant a warrant to search for a document, parcel, or other thing to in custody of the postal authority. So this is a special case. So grounds for issuing a such warrant is given as if there is a reason to believe the person who has received the summon or requisition to produce that particular article will not produce the required document or article, and then a search is required to take it from his custody. If it is unclear to the court if that thing is with that person or not, or something is there with that person or not, then also a search can happen. Or in general, a search or inspection if required in case of that inquiry or trial, then also the court can go back and say, under this trial, under this inspection, under this investigation, you go ahead and make a search also, or maybe as requested by the police officers. So those provisions are designed to ensure that the court can take necessary actions of search in all these conditions. But the specification of search area is very, very important. So whomsoever is executing, they have to be very specific on which area, which sub area, or what exactly has to be followed, and they have to be exactly limited to that, because the searches are done not to go beyond that to uh, take away the rights of the privacy, etc., for the person, or any other rights to be injured because of that. So this is something which is a also granting a specific warrant for the magistrates. But in case of a postal department, if that kind of search has to happen, it can only happen from the district magistrate's permission or from the CJM's permission. Although when it goes to the application to the CJM might pass it on to any of its subordinate court and the order might be obtained from there. So this is a facilitating evidence collection by searches. It is protection of the individual's right also, because we are limiting it only to where we want to achieve something, and there is a judicial oversight which is fixed to it. Section 97. Let's move to the next section. It talks about search of place suspected to contain stolen property, forged document, etc., etc. We If a district magistrate, SDM, or a magistrate of the first class. Now you see suddenly in some cases the DM, SDM also comes in, because this is not only matter of a police, this is matter of a general administration also. Upon information and after such inquiry, as he thinks, if they receive an information or either of them make an inquiry and they think it is fit, that has reason to believe that that place is used to store some kind of or store or sale some kind of stolen property, or for the deposit, sale, or production of any objectionable article to which this section applies, or that any such objectionable article is deposited in that place. So any theft article is deposited or sold, or any objectionable article is which is deposited or sold in that area. Any police officer above the rank of a constable is authorized to, so he may warrant authorities any police officer above the rank of constable. So these people can authorize anybody above the rank of a constable. So what is the above rank of the constable? Havaldar. So the head constable. So above the rank of constable, to ensure with such assistance as may be required such place. So they have to enter and ensure that with assistance, whatever required in such places, they can enter and then they can search the same in the manner specified in the warrant. So it takes a cue from the previous section also, because the search warrants have to be very specific on what article has to be recovered and which area it has to be done, which is automatically imbibed in the next section. To take possession of any property or article therein found which he reasonably suspects to be stolen. So he can take possession of any property or article which is found there, which is reasonably believed to be a it to be stolen property. So he has got a direction, he has got a warrant to come and search. Now it's his own discretion where he has to apply his mind and he has to find that what could be the stolen property, and he can take a possession of that or any objectionable article. What are the objectionable article? The objectionable articles are any counterfeit coin, any counterfeit currency, any piece of metal which is under the Coinage Act, which is broken coin, etc., etc., or some kind of foreign currency, counterfeit currency, some counterfeit stamps of government, any forged document, any false kind of seals of the government, any obscene object, and then instruments of material used to produce any of these objectionable articles. So any of these, if he sees, he can seize those things and take those things under his custody, under his possession. Point E says to take into custody and carry before a magistrate every person found in such place. So he not only has to bring in the articles which the person has taken in custody, he has to bring all the person also in such place who appears to have been privy to the deposit. So who are part of this deposit some way or other, or in the sale, or in case of production of such articles, knowing or having reasonable cause to suspect it to the stolen property, or as the case may be, objectionable article to which this section applies. So this is something which is an authority to issue such warrant whenever, wherever such kind of situations happen, and the district magistrates, SDM, or a magistrate of the first class, JMFC, can issue such warrant based on the information, or if they based on the inquiries, and this can happen. The police has power to take possession of the articles, possession of the people, conduct the search, enter the place, seize the articles, manage the seized property, arrest the people. All those things can happen And definition of objectionable articles is already given, which I discussed a few minutes back. And it is a preventive and an enforcement role of the police and the courts. It's a judicially safeguarding that particular situation. And this is something which is a complexity of the law enforcement is brought forward with this, where any article specified required police officers to have a clear understanding of what constitutes objectionable. So this gives an additional responsibility to the police officer also to look wisely what could be considered objectionable in this case. So that's about section 97.